You mentioned, you identified various lacunae in the law, and one of them was the lack of protection for IP holders and intellectual property generally. You cited the CJU case, and the idea that if you feel you've been discriminated against, you have a right of access. But I presume that you have to have some prima facie basis to show that you've been discriminated against. I mean, you can't just, there has to be some basis for feeling that you have been discriminated against. And I suppose my question are twofold. One is it realistic to, I mean, obviously the lack of protection for IP holders is a very contentious issue now, and it's one that your rapporteur regularly takes up, rightly. But I mean, is this an appropriate piece of legislation in which to address that? But the other is, in the absence of large language model developers or model developers generally outlining what materials that they've used, and it's probably almost every material given the scraping that goes on, then how can you possibly show that your copyright has been infringed or that your copyrighted material has been used either in training or subsequently? Because it seems that everybody probably legitimately feels that their information has been used for training purposes, but nobody's going to be able to demonstrate any particular prima facie or prima facie evidence to a court. So I mean, how could that possibly be remedied?
Just to close, Mr. McNamara, indeed, discrimination and the Meister case, so the CJU said precisely that you cannot have access. And the problem is to even prove a prima facie case, because a prima facie case, for that you need statistical disparities that you show, and for that you need some access to at least some part of the training data. Now, I would agree that this cannot just be anybody. We don't want to have frivolous lawsuits all over the place, so there must be a plausible claim that there could be a disparity, for example, by sampling across, a number of prompts, and then if you make a plausible claim, then you could have access, again, via such a restricted transparency system, if need be, via some independent third party to such data, and there could even be a register for such transparency mechanism, and a register for opt-outs, for example, when we come to IP law again, which is something that is high on the agenda.